Question number 8, named Deputy Clare Daly.
Thanks, Corla. Minister, the Workplace Relations Bill, which we passed last month, I think was a missed opportunity to deal with an issue which you've acknowledged previously must be addressed, and it's one whereby normally when an employee severs their relationship with their employer, they no longer have access to the state's industrial relations machinery. That makes perfect sense in most instances. The one instance where it doesn't is, of course, in relation to people's pension. And people need to be given a voice when their material living standards can be potentially dramatically impacted upon. And given that you haven't done it in the bill we just passed, what are you going to do to deal with this issue?
Thanks, Deputy Daly, for table this important question. I fully appreciate the concerns of retired and deferred members of pension schemes whose schemes are being restructured, particularly where such restructuring may have an impact on existing or potential pension benefits. In this regard, the question of pensioner groups having access to the state's industrial relations machinery in pursuing pension scheme grievances is an issue to which I've given very careful consideration. I have a deep interest in this. Doing so, I've borne in mind that the industrial relations system in Ireland is voluntary in nature, both as regards access to the LRC and to the Labour Court. Any change to that principle which would put in place a mandated right to be part of the process would alter fundamentally the conduct of industrial relations in this country. As it stands, where changes to pension schemes are negotiated at company level, whether as a result of a crisis in the scheme or otherwise, the outcome of that engagement cannot of itself change the pension scheme. Rather, any proposed changes to the scheme are effected through the trust deeds and rules of the scheme, and are at the discretion of the parties so designated in the rules or deeds of the scheme. In my view, it's within that framework, rather than through the state's industrial relations machinery, that a collective approach will be most effective. In terms of changes to pension schemes generally, the trustees of a particular pension scheme are required by law to act in the best interests of all of the members, be they deferred or pensioner members. Until recently, this has been done on an individual basis. The Taoiseach Minister for Social Protection has recently provided for the recognition by trustees and the Pensions Authority of groups representing the interests of retired and deferred scheme members of a particular pension scheme. The required revised Section 50 guidance has been published by the Pensions Authority. From now on, the trustees of a scheme are required to notify the groups representing the interests of retired and deferred scheme members where the trustees of a scheme propose to apply to the Pensions Authority to restructure scheme benefits under Section 50 of the Pensions Act. This notification affords the representative group an opportunity to make a submission to the trustees of the scheme in relation to such proposals. In addition, the Pensions Authority is now required to notify groups representing the interests of scheme members where the Pensions Authority proposes to either issue a unilateral direction under Section 50 to the trustees of a scheme to restructure scheme benefits or to wind up the pension scheme under Section 50B of the Pensions Act. This notification affords the representative groups an opportunity to make representations to the Pensions Authority in relation to such proposals. Furthermore, in such situations where the representative group, furthermore, in such situations, the representative group will also have the option of making an appeal to the High Court in the point of law in relation to such proposals.
Deputy Daly.
Yeah, no, I have to say that is not adequate at all. I mean, the reason why we're in this difficulty is already under existing procedures, trustees have to inform everybody. Notifying somebody of something is not the same as engaging with them or negotiating with them. And that's the difficulty. And I will use the example of the IASS scheme because I think it highlights very well the point being made here. At the heart of this, existing pensioners and deferred pensioners stood to lose an enormous chunk of their income, to which they had a reasonable expectation on retirement, to which they paid into all their working life. The retired members have made the point that $500,000 a month is being taken out of the local economies in cuts to that group alone now. The people who made that decision were existing employees, trade unions, the trustees, everybody sitting around in the expert panel. People who voted on that were members of trade unions in employment who weren't even members of that pension scheme. And the very people whose pockets have been pilfered of this money didn't have a voice at the table and didn't have an input in that process. And I don't hear anything in the answer that tells me that they're going to have a process in the future either, which is just, it's not good enough when somebody's to say, oh, go to the courts or whatever, when people are retired and have limited income anyway. So I'd like to hear concretely what we're going to do about this.
Minister. Yeah, I mean, The Tánaiste herself is very anxious to seek to address this issue, as I was myself, I'm very familiar with the circumstances that Deputy Daly outlines, as the Tánaiste is as well. And it was felt that the appropriate way of addressing concerns in the future would be through the Pensions Authority, and where people would be provided with the opportunity to make submissions to the Pensions Authority in the type of circumstances that Deputy Daly outlined. Previously, I mean, the views of the LRC and the Labour Court were canvassed in relation to the possibility of using the IR institutions of the state to address some of those issues, and they come back with a couple of very fundamental points. And the view was then taken subsequent to meetings between the Department of Social Protection and the Department of Jobs, Enterprise and Innovation officials that it was clear that the solution to addressing the concerns of retired and deferred members of pension schemes regarding representation rights might best be achieved in the context of the pensions legislative framework, and the Tánaiste has made provision for that in terms of the details I outlined earlier on. So that would now be done in the future through the Pensions Authority, through a process there, rather than in the industrial relations arena.
Deputy Daly.
I'm afraid I don't agree, and sadly, if we don't change tack, I imagine I'll be proven right. There are problems with the Pension Authority. There are problems with trustees taking decisions which members are not happy with, and there is a problem with getting appropriate investigation into some of these activities. And the difficulty is you're talking about people's retirement in their twilight years. It's a very, very serious situation in terms of the amount of monies involved, and I don't see why the Labour Court couldn't be opened up to people in the same way as groups, if you like, a trade union can go in and negotiate on its members, even though some people in the employment may not be in that trade union. Retired groups that exist, like, for example, the Retired Aviation Staff Association or other registered retired groups, could do the same for pensioner groups. And it's about having their voice heard in a process that's ongoing, which is often ongoing in a situation where a company is maybe involved in broader discussions on other issues apart from pensions issues, and that it becomes part of an industrial relations discussion as well. So there has to be a voice for them there as well, but there also would have to be a complete overhaul of the Pension Authority, which people at the moment don't feel there's any teeth into them really delivering justice for people who have legitimate concerns. And the IASS scheme is a very good example of that, where serious questions of investment irregularities were raised, and yet still a decision was taken to allow pensioners' incomes be cut rather than answer some of those points.
Deputy Daly raises a couple of fundamental points in relation to the industrial relations machinery of the state, and I think it's worth putting the following on record. I mean, access to industrial relations machinery of the state is governed, as the Deputy knows, by definition of worker, Section 23 of the IR Act 1990, which provides inter alia that a worker means any person aged 15 or more who has entered into works under a contract with an employer. Legal advice that was received by the Labour Court on a number of occasions suggests that a person who is retired cannot be regarded as a worker and cannot be party to a trade dispute capable of investigation by the court. And where a person is retired, they cannot have a dispute concerning their employment or non-employment. The court is, of course, entitled to investigate a matter which arose prior to an individual's retirement and which is referred to the LRC or the court prior to the individual's retirement. So the introduction of access rights for individual retired workers to the industrial relations machinery of the state under the IR Acts, where they have not referred their claim prior to their retirement, that is currently under consideration. But from the point of view of the pensions piece, very important pensions piece, the decision has been taken that the Pensions Authority is the appropriate mechanism where those issues can be explored. And as I said at the outset, the opportunity would be provided to people in certain circumstances where there were fundamental changes being made to their scheme, that they would be provided with the opportunity to make submissions to the Pensions Authority where those issues were being considered.
Thank you.